Hearing in the appeal, Maharaj and another, and Motor One Insurance Company.
Good morning.
Good morning.
You will have to speak very distinctly because the sound quality is not perfect and there is this delay.
Yes, please, my lord. My lord, we're experiencing a bit of a technical difficulty right now in that we are not seeing you on the screen.
Oh, well then we must clearly wait till that changes. Should we retire again while you solve the technical difficulty?
Yes, please, my lord. We sincerely apologize.
No, we will retire and resume when you are ready. Thank you.
Thank you, my lord.
Good morning again.
Good morning, my lord.
Now, lesson number one, I think, for those assisting you, is that the purpose of testing, which is undertaken before any hearing, is to ensure that the equipment works and the equipment should not be changed after testing. Right. The second point we would like to make is if we wish to put a question, I will raise my hand, perhaps also the questioner, but stop then and allow us to put the question.
Certainly.
The only difficulty with that, please, my lord, is that we will only be able to see your hand 30 seconds after you've raised it.
Right. Well, we will have to do the best we can. I'm sorry it is not perfect, but let us hear your submissions. There is one other point that I would like to make before starting, and that is that we received a speaking note, and I think I speak for my colleagues when I say that the procedure is intended to include the argument in the written case and not in a speaking note just before the hearing, in respect of which there has been, with some justification, an objection by the respondent. But we have read it and we will deal with your arguments. But for the future, please try and avoid this practice. A short speaking note is sometimes very helpful, but a complete rewriting of the case is not appropriate. So let us begin, but we're not shutting out any point. We will hear argument on all that you have put before us.
Yes, please. My apologies for that, please, my lord. My lord, seeing that we have lost an hour of the hearing, my inquiry is whether the speaking can stand or if you wish to.
Right. Well, let us hear your submissions. I think your speaking note was intended to a considerable extent to take the place of oral argument, and in that respect it may help. But we have the outline of your case. I think you have two basic points. So would you like to develop them, add to your speaking note rather than repeat it?
Yes, please, my lord.
Yes.
With your leave.
Yes.
Should it please you, my lord, I am Ria Chattergood, and I appear Mr. Torian Dasain and Mr. Prakash Maharaj for the appellants. The appellants are in the courtroom, please, my lord and my lady. Mr. Sean Ruknarain appears with Miss Helen Lochan and Miss Shanta Bhagavan for the respondent. A representative of the respondent is present, Ms. Candice Pear. My lords, we wish to thank you for an opportunity to be heard via video link, and it has proven to be very convenient to both parties. The appeal stems from the Court of Appeal's decision that the relevant limitation period is 4 years, and further, the issue of concealment has not been addressed by a court of appeal. The issues under appeal are twofold. Firstly, is the appellant's action statute barred? And secondly, whether there was concealment to postpone the limitation period. And my lords and my lady, in addressing these issues, we intend to speak to 6 points that are essential to understanding the issues. First is the nature of Section 10 of the Motor Vehicles Act. Second, whether Section 31C of the Limitation of Certain Actions Act applies. Does the cause of action under Section 10(1) of the Motor Vehicle fall within the ambit of actions to recover any sum by virtue of any enactment? 4, whether there is a limitation period for specialty actions in Trinidad and Tobago. 5, whether Section 3(2) of the Limitation of Certain Actions Act applies. And lastly, 6, whether the limitation period was postponed due to the respondent's concealment. In dealing with the nature of the Section 10(1), appellants believe that it does not create a new liability to pay the liability and existing liability under the policy. The right which is given to Section 10 is a new right which does not exist under the common law to circumvent the doctrine of privity. And this is the essential point, that what is the right under Section 10(1). In addition to the speaking notes, at page 206 of the record and 211 of the e-bundle, an explanation on this principle was highlighted, which is, as general principle, a person who is a party to the contract could not sue under a contract. There were some exceptions to that principle, both at the common law and by statute. Section 10 gave the right of action to a person who is not a party to the contract of insurance. He goes on to say, the effect of Section 10, in my view, is to make the insurance company, in the absence of a valid defense, liable for the debt secured by the judgment against the insured. lords, my lady, it must be noted that it is the policy of insurance that is the one that determines the liability of the insurance company to pay. Addressing the issue of whether the action is statute barred under Section 3, 1C. It is noteworthy of the cause of action and when this accrues. With this in mind, the respondent has relied on Central Electricity and Hillington Borough, London Borough.
Sorry, say that again. Which cases? Oh, Central Electricity Generating Board, is that it? Yes.
Yes, my lord. And Hillington London Borough Council.
Yes.
My lord, we say, the respondents further say that the action accrues on the 28th of April, 1998, which is the date of the trial on liability in this matter. The appellant's submission is that this is incorrect and that post office must apply. This is Norwich Insurance Society.
Have you just referred to the Post Office and Norwich Union case? Which case was it you just referred to?
Yes, please, my lord.
Post Office and Norwich Union.
Post Office versus Norwich. Yes. Yes, please, my lord.
Now, is there not a problem here? Can I finish? Is there not a problem here? Post Office and Norwich Union deals with claims which rely on the third-party rights against insurers provisions. In the UK, it was the 1930 Act. And under the 1930 Act, there is an assignment of the insurance rights, the insurance policy rights. But does Section 10(1) create an assignment of the policy rights or a separate cause of action on the statute?
My lord, it is a separate cause of action because of the doctrine of privity, because there's no nexus between the claimant and the insurance company.
Right, so it is a separate cause of action to recover the amount of any judgment sum which is payable under a judgment against the insurer. So it's a separate cause of action to recover the judgment sum payable. Yes. So is it really a claim under the insurance? The judgment is under the insurance, but the right under Section 10 is a separate right which is not subject to the terms of the insurance, is it?
Yes, please, my lord.
Well, doesn't that create a problem for you? Firstly, it's
My lord, essentially, what is section?
Yes?
Sorry, my lord. Essentially, what Section 10 allows, my lord, is a right to sue the insurer directly. So perhaps, my lord, it is suing under Section 10(1) gives the insurer the right to deny the policy or to say what is its purpose. And this is why we're suing under Section 10(1). It merely gives a right to sue the insurer directly. And it circumvents the doctrine of privity to enforce the indemnity contract, please, my lord. At the common law, no such cause of action existed, please, my lord.
But under Section 10, all you can recover under Section 10, all that you can recover is the amount of the compulsory insurance, isn't it? You can only recover liability, such liability as is required to be covered. So that's different from the policy, potentially. The policy might cover more. And secondly, you recover independently of any right of the insurer to avoid or cancel, because what you're recovering is the judgment sum, not the policy indemnity.
My lord, I beg to differ. Or perhaps maybe, my lord, if I may state that it is a recovery under Section 10 for some payable.
Yes?
My lord, we are in agreement with your view.
Is she having some problem? Looking round her.
Is there a problem?
No, please, my lord, if I continue.
Yes, please.
So, my lord, if I were to go back to the Hillington case.
Right.
It must be noted that the Hillington did not consider the judgment of the learned master of rules, Lord Denning. The appellant state that the accrual of action occurred in 11th of August 2005. And this was something that was omitted by the respondent in the past at page 238 of the record, or E page 243, wherein they relied on their case where the accrual of the action was the 11th of August 2005. My lord, the appellant state that what allows the appellants to recover, we must remember that what allows the appellants to recover monies is the policy of insurance. From an academic standpoint, with Dave Utan, he spoke as the contract specialty or the sum recoverable by virtue of any enactment. And what they said is that central to the application of Section 9 is the statute must confer a right to payment of a sum of money in determining what is meant by the phrase sum of money. Clearly excluded from the ambit, Section 9 will be any provision conferring on the plaintiff's beneficiary of a non-pecuniary nature. So it is the appellant that states that Section 10 is a non-pecuniary benefit as the pecuniary benefit is by virtue of the policy of insurance.
How can that be a non-pecuniary benefit? Section 10 says that the insurer shall pay any sum payable under the judgment. That's a pecuniary benefit, isn't it?
Yes, please, my lord, I do understand your point. However, Section 10 bears to give the appellants the right to sue and to circumvent the privity of contract. So whereas it is a recoverable sum, the sum is covered in the policy of insurance. Yes, please, my lord.
Yes.
What it is we wish to distinguish in the case of Central Electric is that the respondent cannot rely on that case because it was one, the right stemmed from the Electricity Act, which is different from a Section 10. And my lord, my lady, I take you to, is there a limitation period for specialty actions in Trinidad and Tobago? And as my lords and my lady would know already, we have no mention of specialty, or certainly it was repealed when the ordinance was repealed. We would like to highlight at page E360 E.
What is the bundle?
Wherein it follows from the absence of any the electronic bundle, please, my lord, page 360.
Sorry, what was the? 360. Jonathan, some of us are working from we must have the page number.
Could you give us the bundle number as well?
And that's,
The bundle number.
so the E page number is 360. The bundle number is 355.
Thank you.
My apologies, my lord. It follows from the absence of any common law concept of limitation that in the event of a lacuna in the statutory provision, no limitation period shall apply. And my lords and my ladies, what I may take you to is the Hansard and so that we have forwarded to your good selves. And we in particular would like to refer to the explanatory note. And essentially, the common thread
What is she referring to?
throughout the houses,
Can you repeat that reference, please? We didn't get it.
yes, please, my lord. If I may take you to the explanatory note
The explanatory notes, yes.
of the House of Representatives Bill. Number 14 of 1997.
Not immediately, but 14th September 97.
I missed those.
See there.
you say 14 September 1970. Explanatory notes to what?
To the bill. I've got the House of Representatives.
Are we talking about the limitation?
It is dated the 17th of June 1997.
No.
Is that the 81 one?
Yeah.
Can you give us a page number, please?
No, it's not. It's not in the. It came separately.
I know this was sent.
Can you read the explanatory notes slowly, the relevant bit? I think you sent it to us electronically, and I think we may not have printed it out in every one of our cases.
Yes, please, my lord. My sincerest apologies for that.
Yes.
Essentially, what we would like to point out in that explanatory note is that it is highlighted there. Generally, the bill would prescribe periods of limitation in respect to the following actions. And it goes on to address tort and contract, respect of personal injuries under the Compensation Injuries Act, arbitration are all 4 years. What is important, please, my lords and my lady, is that there's no mention of Section 31C in that. It goes on to say, for the enforcement of a judgment, 12 years from the date of the judgment. So that is what the appellants wish to highlight there, in that there was actually no mention of Section 31C. And my lord, the email that we sent with the 7 attachments, which attached the explanatory note, dated the 22nd of April, 81. Is that before my lord, or shall I read as well?
Wait a minute. I'm just looking at the explanatory notes. Now, can you just tell me what was your submission on the explanatory notes? I've got them here.
No mention of 31C when they
Yes,
dealt
please,
with
Your
Section 3.
No.
My first submission on,
No mention of Section 31C.
my lord, my first submission. Yes, please, my lord.
Right. But Section 31C repeats a provision which was in the preceding legislation, doesn't it? The preceding legislation had a long clause which included in it judgments and specialty, as well as mortgage.
You mean the ordinance?
The ordinance.
Yes, please, my lord.
So this repeats part of...
The ordinance.
Right. So is there not a possibility that the legislator intended to he intended to deal with specialties in the sense of deeds but he failed to do so. But he did intend to deal with specialties in the sense of sums recoverable under an enactment, and he did that expressly in 31C. So instead of using the old-fashioned term specialty, he dealt firstly with deeds and secondly with sums under an enactment. He also dealt with judgment sums. So he's covered most of what was in the old section. Unfortunately, he has omitted to give a period for deeds. That must be a lacuna. But is there any other lacuna?
My lord, I only see the reference to specialty being lacuna.
Going on here. 1, 2, 3, web citizen. No, it doesn't matter.
Yes, sorry, continue.
My lord, may I proceed to the ordinance?
Yes?
So, my lord, I was pointing you to ordinance of the 22nd, sorry, the explanatory note on the limitation bill
Yes?
on the 22nd of April, 81.
Right?
And what it is that we noted within all the Hansards and all the explanatory notes is this. The bill is a general measure for the limitation of civil proceedings. It does not apply to actions to other proceedings for which a special period of limitation is prescribed by another enactment.
Right?
The bill contains no catch-all provision and consequently a right of action in respect of which no limitation period is prescribed either by the bill or any other enactment is subject to no limitation of time. That is the position under the present law of the state and also under the English law. My lord, that is what we wish to point out with the explanatory notes. And this is why we're saying that no limitation applies. However, for the sake
Right?
However, for the sake of consistency within the law, we believe that 12 years should apply. When you look at the common law. My lord, and in so doing, and in dealing with this lacuna, and with the special relation of section 10.1 action, we must look at the effect. What it would be is that the appellant has 12 years to recover against the insured. But if you were to take the respondent's view, we would have that the appellants, the insured, holds for 8 years, as you only have 4 years to recover against the respondent. So you have 8 years for the insured in excess to be personally liable. this makes nonsense of the interpretation by the respondents, my lord.
Well,
What we also note is that
is not the answer
yes,
that
please, my lord.
you say that the appellants have 12 years to recover against the respondents under the judgment, against the driver, against the negligent driver under the judgment, but only 4 years to recover under Section 10. But in the remaining 8 years, the appellants could still bankrupt the insured, the driver, if he is insured, and then proceed under the third-party rights against insurers provisions if he is insured, against the insurers, proceed against the insurers.
Whilst I hear, my lord, what the appellants would submit is that even with regards to the bankruptcy, that was 4 years. But more importantly, please, my lord, it is the unjust effect of that suggestion as well. What you have is that the insured paid a premium under the policy, but now the insurer is being able to escape that liability. And this is why I referred you to the please, my lord.
Right.
What must also be noted is that when the amendment was made in 1997 to repeal the word specialties, they did not have the benefit of Section 10A in the Motor Vehicle and Third Party Act, which allowed you to bring in the insurance company at the same time, albeit that you may bring the insurance company. Now, again, my lord, it points out the unjust nature of the deletion of the word specialty. Because now, as it stands, you can sue both the insured and the insurer at the same time. However, at the time of this action, that was not possible. So under Section 10A of the Motor Vehicle Act, the 12-year runs simultaneously when judgment is entered. But what you have against the appellant is that you were able to get judgment against insured only as a result of how the law was at that time.
Why do you say that when
My lord,
why do you say that when the concept of specialty was removed, the legislator did not have the benefit of Section 10 of the Motor Vehicles Insurance Third-Party Risks Act, because Section 10 dates from 1996 at the latest.
Possibly 1933.
My lord, it was proclaimed in 1998, please, my lord. So this is why I'm saying that. I believe it was in June 1998, if I'm not mistaken. The 11th of So this is why we're saying that, because then my lord could address your mind as to the unfairness or the inequity that was raised by the deletion of the specialty.
Well. But
So we're referring to Section 10A, the inclusion
Yes.
of Section 10A.
I mean, Section 10, whenever it was proclaimed, goes back much longer than 1996, I suspect.
10A.
Sorry, Section 10A.
My lord, if I may.
Ah, yes, I see.
Yes, Mr. Lord.
Section 10A. you were
Oh,
talking. Yes,
that's it.
yes. Right. Yes, I see.
So this is why the appellant is stating that now you can sue the insurer and the insured at the same time. And the word is may sue. It is not a necessity. But when you obtain a judgment there and your declaration against the insurer, the judgment runs to the same 12-year period, please, my lord. Whereas at the time of the appellant's case, this was not the case.
Right.
And this shows the inequity of the deletion of the word specialty, please, my lord. Just one further point, please, my lord, before I close. And it touches the concealment issue. Essentially, what we wish to enforce or to point out is that I believe it was in 1988 when we sent a letter. 1989 when they responded, they responded.
This is the issue of concealment, is it?
Yes, please, my lord.
Right.
And what I would like to point out is in 1988, when we wrote our initial letter, and that is page 107 of the record, in 1989, when the respondents responded, saying that the vehicle was insured. That is page 108. And my lord, I would get the reference to the 1990 notice where it can be found in the record.
Yes, we have that, page 19.
But when, yes, please. So the notice of the action that the appellant sent in 1990, it must be noted that pursuant to 10.1.3, that the respondent at that time could have set aside the policy. They had 3 months to do so, and 7 days St. Thomas from that notice. But the respondents have not done that. To date, the policy was not satisfied. It stands that the vehicle in question was owned by Cheryl Grant and insured by the respondent.
But as I understand the respondent's case, it is as you have set out in the précis, in the statement of facts and issues. The respondents say we had no insurable interest. So they don't need to avoid.
My Lord, if they are saying, sorry, my Lord?
They don't need to avoid. What they're saying is that they insured a person who was not the driver and not the owner. So they had no insurable interest.
If that is the case, please, my Lord, and that is not before the court, please, my Lord.
Could I ask?
But if that is the case, please, my Lord,
Yes. Okay.
then
Lord,
there's still no provision of the policy of insurance.
Lord Wilson wants to ask a question.
Ms. Chattergoon, you say concealment entitling. You say concealment entitling you to an extension. What is the fact which was concealed from you, which disabled you from suing within, let us say, 4 years? What's the fact concealed from you, please?
My Lord, I understand your statement in terms of the fact, but rather it is the duty of the respondent. Essentially, what we're saying is that the conduct of the respondent is what must be taken into consideration with regard to the concealment issue. And this was explained in Ted and Baker, PLC, paragraphs 44 to 48. But what is clear is that the respondent is now stopped from saying that Mickey Parmeshwar was the owner and driver. And he was not covered by the policy of insurance.
Can I ask, this is
as a result of their letter in 1989.
but this is a point which has only been raised in your speaking note. You did not plead in those terms. You relied on some different facts. Now you say that you have a case of estoppel, but in order to show an estoppel, you have to show reliance, don't you? You have to show that you would have acted differently, and we don't have any pleading or evidence to that effect, do we?
Yes, please, my lord. That is in fact correct. We had raised the concealment point or suggested it at page 349 of the record, please, my lord.
Sorry, which page on
Sorry,
the bundle?
my apologies.
No, 349 is not.
These are the bigger.
And this is,
344.
it's not on that record, please, my lord. It is in the
I think it's
it is in the Court of Appeals below record.
it's
But unfortunately, my lord, that document is not before you.
yes. No, page 99, I think. Page 99.
That is in the amended statement of case, paragraph 15, please, my lord.
Yes.
And
Paragraph.
this was addressed in the court below as well, please, my lord.
I know. But you haven't pleaded reliance. You have pleaded a reference to a witness and also to a document in 2012, which is very late. Now, your present case seems to be quite different.
My lord, the essential point of the concealment that we're raising is basically the duty of the insurer and what is the interpretation of that duty. It's in Thomas. And it is based on the letter that the vehicle was insured in 1989. And to date, the respondent is saying, or perhaps they are not addressing the issue of the vehicle being insured. Please, ma'am.
Could I ask a question, please?
Yes.
And those are the appellant's submission in that regard.
Lord Wilson wants to ask a question.
Ms. Chattergoon, you have kindly referred us to a transcript of what one of the defendant's officers said at the trial, which I believe was in 1998. We've got it, and you needn't turn it up, at page 200 in the record. And somebody seems to have asked her whether this particular registration number, PT6676, was insured by the defendant. And she said, and thank you for pointing this out to us, I can't say. And then the questioner said, if you have access to the records, can you tell us? And the lady said, I don't have records. And you're relying on this in your paragraph 15 that you've kindly showed us. But of course, even if the lady didn't know what she was talking about, and here I'm looking at what you've kindly numbered page 111 in our record, you have kindly showed us that 10 years ago, on the 13th January 1989, your insurers were accepting that Cheryl Grant was insured by B&L for this particular motor car. So the lady may have been unhelpful in 1998, but back in 1989, and from that point onwards, you knew perfectly well, didn't you, that B&L was the insurer of this motor car, and that the insured person, forget about drivers, the insured person was Cheryl Grant. Thank you for listening to me. I'm sorry my question was long. What's your answer?
My lord, I must agree with you. And essentially, whilst we knew and still know or believe and rely on those letters, 1989 and so on, that the vehicle was insured, it is conduct of the respondent that hid the scope of the policy, for want of a better expression. So yes, they're saying that Cheryl Grant in the 1989 letter, the vehicle was insured. They continue to hide the policy or the scope thereof. And we are uncertain as to what the policy entails or what the scope entails. And then we would rely on the Richardson Hill, because it's essentially only if they provide that policy, then we can know the scope, please, my lord.
Have you
And that is why we're saying that it was concealed.
Have you ever asked for the policy, and who did you ask when?
Yes, please, my lord. We have asked on several occasions from the letters, if I may refer, my lord. Bear with me. Even further to those requests which were made out of court, please, my lord. Justice Scandaloo, and she had made an order specifically asking for documents relative to this.
No, this is the order is long after you began the proceedings.
That is page 3.
The order is long
Yes,
after
please, my lord.
the order.
All the letters that
The order is long after you began proceedings. Under the legislation, against whom or from whom do you have a right to ask for the policy?
I believe it is the insured, please, my lord.
Yes, it is against the insured. Did you ever ask the so-called insured, the defendant, for a copy of the policy or for details?
The resulting effect of that was C policy 501, which he stated, please, my lord. And then, in terms of the letters from the appellants, in the record, perhaps 149 to 165, 139 to 145, and 169. If I may repeat that, please, my lord. 139 to 145, 149 to 165, 169, you would see that at all material time, the appellant was trying to ascertain the scope of the policy.
Could I ask a question?
Yes.
Ms. Chattergoon.
And these were well before the order.
Ms.
Yes,
Chattergoon.
please, my lord.
Thank you. You say that you don't know who the permitted drivers are under the policy because the respondents have been so unhelpful. My question to you is, that did not disable you from suing them in 2013, and why then couldn't you have sued them on the same basis in 2006?
My lord, I do hear your question, but what the appellant will state is that even though they inquired in terms of the scope of the policy and they remain without answer, if the appellants are impecunious and injured, and had they filed an action one could consider prematurely or without correct information, there was a risk that a court order would be awarded against it. And my lord, that is respectfully the appellant's view.
Thank you.
But as far as I can see, you have not shown any evidence that you pressed the respondents for the policy at any stage until after these proceedings.
My lord, the most I can answer to that is to the letters that we had indicated to the respondent. And in any event, at the letter in 1988 from Mr. Ramesh Lawrence Maharaj, it says, that is the letter from the appellant's attorneys. It says, and my lord, that is at page 19. Our clients claim damages for the personal injury losses, expenses, and inconvenience arising from this accident. We shall be obliged if you would confirm that this matter has been reported to you by your insured. Our client Ramprasad Maharaj was the owner of motorbike PAR 250. And we cited that the accident was caused through negligent driving of motor car registration, PT 6676. It's on that basis that BNL responded at page 21 of the record. And what is important there is that they say that they are in possession of a report of the accident involving the two vehicles. However, our insured's report indicates that the accident was caused by the negligence of the driver.
Yes, but
they further state that they are investigating the matter.
This is not really dealing with the central point. You say there is some estoppel from denying that they were the insurers, but that is still no reason why you did not sue in time. You knew who they were.
Yes, please, my lord. The only reason that I can afford the adverse cost order, if it is that they were wrong, because at all material times, the appellants tried to find out whether Miki Parmeshwar was covered by the policy. Yeah. And that would be the appellant's submission.
Yes. Right. Is there anything more you want to add?
Yes, please, my lord. May I refer, my lord, to page 27 of the record? Which is the notice pursuant to section 10 that the appellants had to give. Wherein we specifically enclosed a copy of the writ of summons.
Yes.
So a copy of the writ of summons was, sorry, madam. A copy of the writ of summons was forwarded to the respondents. The importance of that is that it cited Miki Parmeshwar's name. And it was at this time that it should have been invoked under section 10.3 to inform us of whether the whether the defendant was covered the punishment. And my lord, those are the appellant's submissions, unless if I could be of any further assistance.
No, thank you very much.
Thank you, my lord.
Thank you.
You're welcome.
Well, headlines at this.
Yes.
Headlines.
Yes. Mr. Nareen.
Thank you very much, my lady.
You can take it quite short.
Can I take the court directly to?
I was going to say you can take it quite shortly because we have had the benefit of your written submissions and also of the discussion we've just had with Ms. Chattergoon.
Indeed, my lord, and I realize that a lot of the areas that I wish to address, your lordships have identified already. My lord, looking at section 10.1, the respondent submits that the insurer is liable to pay to the persons entitled to the benefit of the judgment any sum thereof. That is the essence of section 10.1. Thus, the section 1 is an action to recover a sum recoverable by virtue of that enactment itself. And so we fall squarely within section 3(1)(c) of the Limitation Act. Support for that position is obtained by the respondent from two sources. One, the case of Matadine, and two, consideration of the previous legislation that was repealed. I propose to deal firstly with the Matadine decision, and which is the Matadine decision is found on the e-bundle, pages 691 to 704, and at tab 7 of the bundle of authorities.
Yeah. Yes. Well, you rely on the Matadine. You rely on the Matadine decision as authority that Section 10 creates a new cause of action, and it is different from a cause of action under the third-party rights against insurers provisions.
Paragraph 39.
That is so, please, my lord. We also say that at paragraph 9, the court there identified that the effect of section 10.1 was to make the insurer liable to meet any judgment obtained by an injured party.
Yes.
Now, my lord, we'll also use the Matadine decision for saying that at paragraph 39 of the decision,
Yes.
the board contrasted the section 17 cause of action as against the section 10 cause of action, and identified the section 10 cause of action as being an action on a statutory cause of action created by the section, thus being a specialty. Now, Lord, I would then next take your lordships and milady to the limitation ordinance and the limitation act. So the limitation ordinance was forwarded to the court by way of email, and the limitation act is found on the electronic bundle, pages 586 to 588 in the electronic bundle, and the tab 1 of the list of authorities. Is the court with me?
Yes?
So, it is just to compare, my lords, that there's only an updating of language as was identified by the court earlier. Both under the Ordinance and under the Limitation Act, they were both framed as being actions to recover. Under the Limitation Ordinance, the archaic word used is specialty. The language has been modified and brought up to date, call it an enactment. And that is the simple point that we make. Otherwise, the provision is the same. And so unless your lordships wish to hear me any further on that point, I propose to move away from it.
What happened about deeds in the modern legislation? Did they forget to put in a limitation period?
It does appear so, respectfully, because there is in the sections 3.1 A and B reference to contracts under seal, and it does appear that there is ultimately no dealing with those particular deeds. So it does seem that there is that lacuna in relation to those items outside the scope of what is concerned here directly.
Lord Wilson?
Mr. Root-Narine, of course, the 1997 Act was strongly based on the 1981 Act, which never took effect because it was never proclaimed. And I raise this only because of my Lord Mance's question. But actually, Section 5 of the 1981 Act did have a subsection 2, a provision about actions on deeds. But curiously, that was omitted from the 1997 Act. And correct me if I'm wrong, that was the lacuna that Mr. Justice Boodoo Singh had to wrestle with. But you say it's not a lacuna that we have to wrestle with. Is that right?
That is exactly the point. Thank you very much. That is, the respondent says that as far as our case is concerned, there is no lacuna.
Right. Thank you.
Now, to this, so what I say is that we fall within the ambit of the section, and the question when the time begin to run. And for that, there were two options. The first is the time began to run upon the obtaining of the judgment in 1998 before Justice Musai. Or secondly, it arose from the date of the assessment of damages before Master Paradurity in 2005. In either event, the respondent submits that the applicable limitation period is a period of 4 years. And in either case, the appellant's action now is statute barred. Do your lordships wish to hear me, on that particular point?
No, but
No.
he's right on 4 years, it doesn't.
Yes. I don't think it matters. Even if you took the final assessment of costs, the claim is still more than 4 years out of date.
The privilege could. Could I then move to the last issue, which would be the issue of conduct / concealment? And we say that the respondent, the appellants, always were aware of the information that would enable them to bring the cause of action, to bring the claim that they have eventually brought. There was nothing that changed. There was no impediment to them bringing the same action that they eventually brought. And that is my simple submission.
As a matter of fact, is there any material showing that you were ever asked for the policy in the bundles?
Not prior to the action
No.
being initiated, please. In any event, my lord, I do submit that the policy directly would be irrelevant to the cause of action, because this is a statutory cause of action, and the policy has no direct relevance to the statutory cause of action.
Oh, that can't be right, can it?
Lord, thank
Once you get a judgment against the driver, you can't claim against any old insurer. You can only claim against an insurer who has issued a certificate of insurance to someone insuring the driver. So they would have to prove under section...
Lord, I accept that, my lord.
Yes.
What I'm saying, my lord, is that the appellants knew that the respondent had said from early on that they had never denied that the vehicle at one time through Cheryl Grant had effected a policy with them. That had never been an issue. They had admitted it from the very second piece of correspondence, the first being the letter from the appellant's first attorneys at law. And the answer had been that, okay, we've received this from our insured. So the appellants had also given the section 10 free notice as is required to the appellants. So clearly the appellants knew at all times that the respondent was the particular insurer concerned. I don't know if that has answered your lordship's query of me.
Yes. Thank you.
I'm grateful to your lordships. And to my lady.
Yes, Miss Chattergoon.
My lords, I don't wish to reply, but we wish to rely on everything that was stated before the appellant's case on the speaking room.
I'm sorry, you do wish to reply?
Unless if I could be of any further assistance.
No, have we got any questions?
We don't, please, my lord.
No?
No, thank you.
Thank you. We have no questions. If there's anything you want to say...
Thank you, my lord.
Thank you. The court is grateful to counsel...
My lord,
Yes. Yes, carry on.
My lord, at this juncture, my lords and my lady, at this juncture, we wish to thank you for entertaining us on this matter.
Well, we're very grateful, and we are sorry that the link was not better. We will have to work on that, but we are sure that you were better to stay in Trinidad and Tobago than to experience the very bad weather we are having here. And we will reserve our judgment and hand it down in the usual course. Thank you both very much for your assistance. The court will adjourn.
Thank you, my lord.